Thank you. Well, that was sort of depressing, Rick. Rick gave us a good view in the rearview mirror about what's happened. I want to look through the front windshield and talk about what's coming at us in terms of the cases the Supreme Court's likely to be dealing with over the next couple of years. Let me say by way of disclosure that in each of the three cases I'm going to discuss, I'm co-counsel for either a party or an amicus, so I don't come to the discussion with the sort of purity of heart and soul that an academic like Rick does. But for these purposes, I'll try to be dispassionate and not engage in advocacy. The reason I think it's important to think about the cases in the pipeline, courts are passive institutions. They can't reach out and decide things that are not before them. They can only deal with the cases that come to them. So the cases coming to them in this field and the issues in those cases will importantly determine what happens to the doctrine and the jurisprudence on campaign finance issues. The first case is a case at the Supreme Court that will be decided sometime before the end of next month. And that's Citizens United versus Federal Election Commission. It's really a follow-on case to the Wisconsin Right to Life case that Rick talked about. And it principally addresses an issue left open by the court in WRTL, which is when you have an electioneering communication that is not the functional equivalent of express advocacy, and therefore cannot be subject to the funding restriction, the restriction on using corporate funds to pay for the communication. Can it nonetheless be subject to a disclosure requirement? Now, there is another issue in the case, which is an issue that seemed to be secondary at the initiation of the case, and kind of as the case moved its way through the court system has taken on greater and greater prominence and virtually dominated the discussion at the oral argument, which is whether the funding restriction, the ban on using corporate money to pay for electioneering communications, can apply to the type of communication at issue in this case, which is a 90-minute documentary, as opposed to the way we typically think about this provision in the McCain-Feingold law of regulating 30-second or 60-second broadcast ads. Now, the facts here, Citizens United is a 501c4 nonprofit group. It produced a 90-minute documentary which discussed and criticized Hillary Clinton while she was a presidential candidate last year. And it was going to be disseminated by cable in the states in which she was running in the primary election in the immediate pre-election period, and therefore it qualified under the statutory definition of an electioneering communication and would therefore be subject both to the corporate funding restriction and the disclosure requirement. In addition, Citizens United produced 30-second ads that it wanted to broadcast to promote the film, sort of commercials for the film. It was widely accepted, and the FEC agreed that those ads were not the functional equivalent of express advocacy because they were, in the parlance, susceptible of a reasonable interpretation as being something other than advocacy against Hillary Clinton, i.e. they could be understood as commercials for the documentary. Citizens United filed suit to argue that the documentary should not be subject to the funding restriction because it was not the functional equivalent of express advocacy. It maintained it was an educational film about Clinton or discussed issues relating to the campaign, but it was not advocating against Clinton's election. And it also claimed that the money spent for the commercial, for the 30-second commercial, should not be subject to the disclosure requirement because that was not the functional equivalent of express advocacy and therefore could not be subject to any regulation, including disclosure. The district court, a three-judge district court, rejected both claims, and it said the documentary clearly was advocating against Clinton. It was very critical of her and attacked her character and fitness for office, and it upheld the disclosure requirement on the basis of the court's decision in the McConnell case, which on a facial basis had said the disclosure requirement was constitutional. Now, when the case got to the Supreme Court, a couple of interesting things happened. First, Citizens United changed lawyers, and with it, it really sort of changed the focus of the case and the nature of its argument. And it really launched a kind of reinvigorated attack on the funding provision, the corporate funding provision, and it made a whole series of arguments, sort of layers of arguments. First, they said that the funding restriction really shouldn't apply to a 90-minute film, a documentary-type film, that what that restriction is about, what that provision of the law is about, really is more classic types of political commercials, the sort of 30 and 60-second ads. Next, they argued that, well, even if in general it's going to apply to documentaries, there's something about the dissemination of this documentary which should make it not apply. And that's because their plan was to disseminate the documentary via cable, but through on-demand video, so that a viewer would have to go into the cable system and affirmatively choose to see the documentary. And they said that, well, that's a very different situation than the typical situation of a viewer sitting there watching, Grey's Anatomy and having a commercial come on where there's no affirmative specific choice by the viewer to see the political message. They also argued that the prohibition should not apply to a group like Citizens United, which was a nonprofit group, and even though it took some money from business corporations, it said it was substantially funded by individuals and therefore should be exempt from the funding provision. And finally, as Rick mentioned, and most dramatically, they said the corporate funding restriction is unconstitutional. And you, Roberts Court, should overrule the Austin case, and I think fairly read it would also mean overrule the McConnell case, in which the long-standing ban on corporate funding of political messages of express advocacy has been sustained. That's the broadest ground for the ruling. So this case, I think, will give a good indication of where we're going to go with the Roberts Court